So welcome everybody to our webinar on current medico-legal issues, what you need to know. I'm Georgie Haysom. I will introduce our panel in a moment, but I'd like to start by acknowledging the traditional custodians of the land on which we're all meeting around the country this evening, and their connections to land, sea and community. We pay our respects to elders past, present and emerging, and extend those respects to any First Nations people here with us this evening. Welcome everybody to the webinar. So let me introduce our panel. It is a medico-legal webinar, so we've got an even split between doctors and lawyers on our panel this evening. Firstly, I'd like to introduce Dr. Michael Wright. He is a Sydney-based general practitioner and of course our Chief Medical Officer at Avant. Welcome, Michael.
Hi, Georgie.
Also on the doctor's side, we have Dr. Mark Woodrow. He is a senior medical advisor and claims manager at Avant, and he's an emergency physician, has been in the emergency department today and joining us this evening. Welcome, Mark.
Evening, Georgie. Thank you. Welcome, everyone.
Behind the scenes, we have Dr. Patrick Clancy, another senior medical advisor at Avant. He'll be posting things in the chat. So that's our three doctors involved. We also have our three lawyers, one of whom is me, and we also have Ruan Brell. She is a senior lawyer from Avant. Hi, Ruan.
Hi, Georgie. Hi, everyone.
And behind the scenes, we have Tracy Pickett, another senior lawyer from Avant. She'll be posting things into the chat. So welcome everybody. It is the first time that we've done a medico-legal update, and the aim of this webinar is generally to give you an overview of some of the recent issues that have arisen. We were always planning to do something on Medicare, and it's quite lucky, I suppose, in some ways that the issues have come up. So we'll be spending probably a bit more time on Medicare than we had initially planned, and we'll do our best to answer your questions. Thank you for sending them through. We'll also give you a bit of a quick update on a few other developments. So a quick update on adverse event management and the new statutory duty of candour, which is about to start in Victoria, and also on obligations relating to psychosocial hazards in the workplace. So as I said, we're going to focus primarily on Medicare. It has been in the media recently, and you probably couldn't have avoided it over the last week or so. But before we get into it, there are a couple of key recent events to mention, and I'm going to just pass over to Ruan to do that now. So Ruan, over to you.
Thanks, Georgie. So we just wanted to touch on a couple of recent changes that, that will affect you all and that are relevant in the landscape. The first one of those is that a couple of weeks ago, the Queensland Parliament passed changes to the national law, or its full title being the Health Practitioner Regulation National Law. Those changes won't affect the way that you practice or the freedom with which you practice. They won't impact upon the integrity of the doctor-patient relationship. Largely, they're in relation to the powers of the regulator to investigate, and one of the changes is the power to issue public statements. We address that in our submissions, which are available on our website. There was also a proposal initially that the ban on testimonials in advertising would be lifted, but due to the other developments that are going on in the cosmetic surgery landscape, that was excised from the legislation. So that change hasn't gone through. So just to be aware that that is still banned in advertising. We expect those changes to come into force shortly, and we'll keep you updated about those. The other thing that we just wanted to mention from the start is it's the day after budget night. So we just wanted to mention that there were no surprises in the health and aged care portfolio, as most of you will have seen. One of the core themes was funding for strengthening Medicare and rebuilding primary care, which is relevant to our discussion tonight.
Great, thank you very much, Ruan. All right, so we'll move on to the substantive part. It was good to have that quick update. So thank you, of course, to all of you who submitted questions in advance. They were really helpful. We have combined those questions that we've received into some general questions that I'll ask our panelists. So we may not deal with your specific question, but of course, as I mentioned, if you do need specific advice, contact our medico-legal advisory service. We'll do our best to get through as much as we can this evening. So there has been a lot of media coverage about Medicare in the last week or so. We did want to check in with you all. So how concerned are you as a result of all that media coverage? If you just put some thoughts into the chat, maybe rate it from 1 to 10, with 10 being the most concerned. So if we give a bit of an idea about that. And the other thing we're interested in is, have you received much pushback from patients? We've heard a few people have had a lot of pushback from their patients. So great. Thank you for putting all that in. We've got a few great, a bit of feedback in there. A lot of people are concerned about Medicare issues. So let's launch straight in. Michael, you sent a message to all of our members at the end of last week about Medicare. It has been very concerning, some of the allegations that have been made. Can you just run through your thoughts on Medicare and the issues that have come up in the last week or so?
Sure, Georgie. Yeah, you're right in saying this has been quite dismaying. We know at Avant that issues around Medicare and understanding Medicare and issues around compliance have been a major concern for many of our members, even before the recent reports. And those reports about widespread rorting of Medicare were pretty distressing. And I can assure you and our attendees that that doesn't align with Avant's experience of assisting members with Medicare issues. The overwhelming majority of doctors want to do the right thing. They bill Medicare appropriately and in accordance with the rules. We know that Medicare is complex and it's getting more complex. We've had over 500 new item numbers since the start of the pandemic. And with that complexity, it can sometimes be difficult to know exactly what the right item number is. I know from my own experience as a GP that the item numbers and rules can frequently change and it's difficult to keep up to date. I suppose I'd also thank everyone. Many of you have shared your thoughts and experiences about relating to Medicare in our recent survey. And with over 1,000, actually close to 1,500 responses, the majority of respondents raised concerns about Medicare, including regarding Medicare billing, and early career doctors in particular reported they lacked confidence in understanding Medicare compliance. So we know this is a big area. We see our role at Avant to support you to be confident to use Medicare and how to be compliant. And we've put a lot of resources together tonight that we'll post in the chat. We'll share them after the webinar, and then we'll also try and run through some common questions we've received. We've also updated our Medicare frequently asked questions page, and we have a broad range of attendees. So we'll try to provide general advice and sort of point you in the right direction. We'll try not to delve too deeply into specific item numbers, but we'll tell you where you can get more information and hopefully answer as many questions as possible.
Great. Thanks very much for that, Michael. And we will put that link to the frequently asked questions in the chat for you. And as I said, we'll send them out to you later. So we thought you might be interested to know, Michael mentioned that the survey of members that we did recently, prior to the media reports actually, and we had about 1,500 responses. I know many of you are concerned about Medicare, and in fact, you are absolutely not alone. If you have difficulty keeping up to date with or understanding Medicare's billing requirements and the like, you're in good company. Only half of our members agreed that they understood Medicare's billing requirements, and just over half agreed that they knew where to look for information that they required about Medicare billing. So we're hoping to help you solve those problems with our material, which will have links through to the information. So we'll start by looking at some of the general Medicare type questions, and then we'll move on to some questions around compliance. So I'm going to ask some questions of you, Michael. So many members have asked us questions about provider numbers. Can you just give us a bit of a summary on the position in that regard?
Yeah, so look, this is a common one. Doctors are issued provider numbers for each location they work in, and that include doctors who are based in hospitals. You need a provider number to bill Medicare items from the Medicare benefit schedule or the MBS. As the billing health professional, if you are responsible for the accuracy of item numbers that are billed under your provider number. And that means making sure that the items that were billed were appropriate and necessary, met the time and content requirements of the particular item, and that they're documented. And that can be a challenge sometimes for some doctors, in that many of us have got administrative staff who can do billing for us or assist us, but you need to have a system in place to check what's been billed under your name and to confirm that the billing under your provider number is appropriate. So in some practices, you can get a printout of it. That might be harder in other places, but you can do that through HPOS, which we'll talk to a bit later. And we have had examples where doctors have had to justify their Medicare billings where they haven't been aware of them. So I suppose that's the important news.
Thanks, Michael. Another question that we've had is, can we bill Medicare and bill privately for the same consultation or procedure?
Yeah, this is a common question, and that subject to any specific restrictions, you may bill more than one MBS item number for a patient on a single occasion, as long as each item is medically necessary for the appropriate treatment of the patient and that all necessary elements of the services are met. So you can bill more than one item number, and you can also privately bill and also bulk bill them. In terms of billing two at once, there are often specific restrictions which apply to particular items or to groups of items in the MBS, where it says one service is associated with another, or it might say in the item descriptor, there's a phrase like when no other procedure is performed. So it is important that you familiarise yourself with the full item descriptor and any applicable explanatory notes, because there are a lot of exclusions, even though in most cases you can bill more than one item. And in terms of the payment idea, you can, as I say, privately bill one item and bulk bill another one for if there are multiple item numbers for the patient, but as long as you meet all the indications for both item numbers.
Thanks, Michael. Now, someone's asked a question about whether or not Medicare is reviewing the appropriateness of item numbers. I think there was a Medicare task force a few years ago. What's the current position in relation to that?
Yes, so the MBS task force reviewed the whole of the MBS and placed its report to the previous government. And those, there are a number of committees that were set up to audit, and the Medicare review process is going to be an ongoing process. But we just haven't seen the details of what is planned now that the reports from the previous task force have come through. Although there is also a strengthening Medicare task force, which is now looking at the sustainability of the health system more broadly and focusing more on primary care. So another task force is there. So there is still plans for ongoing review.
Okay. All right. The next question, this is a bit of, quick fire questions actually. Next question is, how accurate do you need to be when it comes to claiming item numbers? We've had lots of questions around complying with the item numbers. So what are your tips there, Michael?
Well, I suppose, as I've said before, if you're using your provider number to bill these items, you need to ensure that you meet all the criteria. So it needs to be clinically appropriate. It needs to be indicated. You need to meet the relevant time criteria if there are some. It needs to be necessary, and importantly, it needs to be documented. So if all of those things are there, then by all means, and you've read the item descriptor and there are no exclusions, then there is eligibility.
Okay, great. And then another question, another general question, there's been a few in the chat we'll get to in a sec. If you've got, can you bill multiple people in a room at the same time?
I suppose that yes and no. I mean, you can only bill one patient for the same time period. So if you've got 3 people in the room, you can't bill all 3 of them for the same 15 minutes. But if you provided a clinical service that might have met both the time criteria and the clinical indication, you could bill two or more, but they need to actually meet the time criteria.
Okay, great. I might jump to a question for you, Ruanne, because we're talking about item numbers and there's been a couple of questions in the chat. How are questions about specific item numbers best addressed?
Yeah, thanks, Georgie. So the department actually has an email service called Ask MBS, which is the best place to go to for any questions about specific item numbers. You can send them an email. The best approach is obviously you don't have to provide specific patient information, and in their information they say that you prefer not to, but obviously it's a good idea to be as specific as possible in terms of what your query is. Read the item descriptor first on MBS Online, and then you can actually refer to specific parts of that, what you don't understand or what you're trying to achieve. And then Ask MBS will respond to you. We have had some questions that came through in advance about whether or not you can rely on that answer. And actually the department makes it clear that Ask MBS as a service works closely with policy areas within the department and with Services Australia to ensure that answers to that are accurate, authoritative and up to date. So you can rely on those answers. If you get a response that you either feel actually doesn't really address your question or maybe is still confusing or it raises another question, then by all means go back and ask again or seek clarification about that point so that you can confidently move forward. If you still are confused, then by all means come to us through our medico-legal advisory service, and we'll help you try and understand those issues. If you have received a response from Ask MBS and you understand that, and then you bill in accordance with that response, then you're entitled to rely on it, and it is exactly the sort of thing that we would use in defending any sort of query or concerns that were raised about your Medicare billing.
Great, thanks, Ruanne. I did want to ask you one of the other questions that's come into the chat. Michael mentioned about the need to check what items have been billed against your name. And one of our members has said, well, that can be not very helpful because the practice changes what you've said, after the event. Can you give some ideas or some tips on how you might deal with that suggestion?
Yeah, so obviously the practice shouldn't be doing that. We absolutely acknowledge, and in the realities of day-to-day practice, it is entirely appropriate for you to get administrative support in processing your billings. But you, as the doctor holding that provider number, as Michael said earlier, are individually responsible for everything billed under it. So if you have checked and approved your billings, and then you become aware of the fact that that is being changed by the practice afterwards, then that is something that, in an ideal world, in a good workplace environment, and we'll be talking about that a bit later, you would be able to raise that with them to explain to them, look, that's not okay, that's not what I wanted to bill that patient, and the reasons why, and hopefully that would be resolved in a straightforward way. If it's not, and it's part of a bigger problem, or you've got concerns about that, then again, reminding them that you're individually responsible for that. It also might be worth, and we've got some information on our website about this, understanding that under the shared debt recovery scheme that was introduced, practices actually can also be liable for any Medicare debt. So if you were able to show that you'd approved your billings, that they were changed after the event, and that you'd raised your concerns and then those were billed, the practice may actually then become liable for that debt, not you individually. Also, if you do find yourself in a situation like that, please contact the medico-legal advisory service, because that might be part of a broader employment issue or a workplace situation that we can talk you through.
Thanks, Ruanne. Before we move on to compliance, because we want to cover that off, and I've got a few questions for Mark, because he hasn't really said anything much yet about the role that Avant can play to help support you. I do have a couple of questions, Michael, for you. We've had a couple of questions about, if you're bulk billing, can you charge another fee to the patient?
Yeah, this is also one that members have asked us for a number of iterations. So the simple answer is no. So if you bulk bill a patient a service, you are not allowed to bill them any other fee associated with that service. Now, it doesn't mean you have to charge them an out-of-pocket. You could actually charge them a schedule fee and they have no out-of-pocket cost. But if you choose to do the bulk billing process, there's a whole list of exclusions that are listed in the Medicare benefit schedule, including you can't charge treatment room fees, you can't charge for dressings, and so it's quite prescriptive.
Okay, great. Thanks very much, Michael. There's been a lot of great questions in the chat that we're not going to have time to deal with, but we are continually updating all of our Medicare information. So we will absolutely be assured we will look at all of those questions and make sure that we have answers to as many of those as we can. I did want to move on to Medicare compliance, though, because when our survey that we mentioned before that we've done of our members, 60% of the respondents said that they were not confident if they had to deal with a Medicare compliance activity. So that's a fairly big issue and a big lot of doctors who aren't, a lot of our members who aren't clear on how to do that. A lot of people are worried about the PSR, which is the Professional Services Review, but there, of course, are very many other compliance activities that the department can engage in. So, Michael, I wanted you to just point out for our members what those different levels of compliance are.
Thanks, Georgie. Look, the Department of Health has what they call a compliance pyramid. So they have a series of layers of compliance activities that they're involved with, and we'll post the link to some of the Department of Health's resources. I think importantly, the largest part of compliance activities that most of us will deal with is education. So there's a lot of resources on the Department of Health website, including ask MBS advice, prescribe patterns of service, which just explain common areas of concern. There's a whole area on chronic disease item management. There's billing in public hospitals. So there's a lot of information there that explains a lot of the commonly asked questions. And that education is, I think, where most of us hope to remain, and that's what we try and support at Avant. The next level is what we call more targeted compliance. So this could include a letter from the Department of Health asking you to review your practice. And this might occur if you bill an item more frequently than your peers. And at this point, it's worth reviewing that letter, reflecting you have met all the criteria for the item. And it doesn't necessarily mean that you've done something wrong. Your practice may have you might have a particular patient base that means you do more of a particular item. And as long as you've got as long as the items were clinically indicated and documented and you've met all the criteria, that's fine. You're given the opportunity to review the billings there, and you also have the opportunity to make a voluntary repayment if you might have been inadvertently non-compliant. The next layer up from that is we then have audits and professional reviews, and these are usually prompted by sustained non-compliance or inappropriate practice. And the PSR is part of that process that many of us have heard about. And then uncommonly, and unfortunately, this may sometimes lead to further action, which includes review or breaches and statutory offences. And then finally, at the top is potential criminal prosecution in cases of fraud.
It's always good to end on the most scary one, isn't it? Yeah. And I think it's fair to say, though, that that's a very, very small number of practitioners who are prosecuted for fraud. I think that we have to make that clear. I now want to go on to sort of the role that we play, Mark. You, as a claims manager and medical advisor at Avant, do look after members when they have claims and complaints, and also when they have Medicare matters. We have many members who contact us for assistance. I'll ask you about the role that we play, but firstly, a lot of members ask us, you know, why did they receive a letter? Michael mentioned the letters that you can receive. Why did they receive a letter? You know, some members have said that they might have more complicated patients, or they might do more long consultations. Are they likely to be picked up and audited? So how does Medicare identify unusual patterns of care?
Thanks, Georgie. Well, as you can understand, Medicare has a vast amount of data that they get from Medicare billings across the country, and it embarks on routine and targeted campaigns from time to time and utilises this mountain of claims data to inform their processes. This is part of the governance to control the Medicare budget, and as a citizen, you would hope that the money you contribute in your taxes is wisely spent. If you bill an item number more than anyone else, or your billing profile is substantially different from your peers, it will come to the attention of Medicare through this data analysis. Now, this doesn't mean that you are billing incorrectly or underperforming. As an example, and a common one that we see, a general practitioner whose practice has developed into largely or solely skin cancer medicine will have a substantially higher procedural item number burden than and particularly those who do the very difficult and complex skin cancer surgery will have a very skewed billing profile when compared to their peers, and their peers are every other general practitioner in Australia. And so quite often that profile will be a little unusual to Medicare, and it'll come to their attention. So in this example, when you're confronted with a billing profile compared to the national profile of GPs as being very different, what Medicare wants is, well, why is that different? And what we are required to provide is an explanation about why this profile is different. And this is a very commonly the target of what's called review and act letters. They've found an anomaly or someone who sits in a very high sort of a standard deviation from the mean for their billing for that particular item number, and they want to know why. If you're the #1 biller in Australia for a particular item number, it's going to come to the attention of Medicare, and they want to know why. But our role then is to explain to them, well, you know, I bill this many of these item numbers because this is my practice, and this is why I am different to my peers. And that's basically how it works. So just because you get a letter is usually just from, you know, a fairly blunt data trawling from Medicare to identify the outliers.
Great. Thank you. Thank you very much, Mark, for that. Michael, I was just going to ask you, are there any other rules that we need to be aware of in that regard?
Look, I suppose a couple of other compliance things which people may have heard of is what's called the 80-20 rule. and more recently the 30-20 rule. So the 80-20 rule means that if you bill more than 80 items on more than 20 days, you are automatically the subject to compliance activities, even if you can prove that the services were indicated. And more recently, there's been an item number, which is called the 30-20 rule, which is a similar prohibition of billing more than 30 or more telephone attendance item numbers on 20 or more days. So they're just a couple to watch out for, that even if you did feel you're providing clinical care, you will raise the interest of the compliance team if you do them.
Thanks, Michael. And we've just popped something in the chat in relation to that. And again, the link we'll send through after the event. There was a question, Michael, in the chat that you may be able to answer, or at least point our members in the right direction, about Medicare billing in outpatients.
Yeah.
Can you answer that question?
Yeah, so this is something which many of us haven't been seen for years, but there is a exception within the National Health Reform Agreement that means that if a patient is being treated by a named provider in a public hospital and they're referred to outpatients with that named referral, then they can raise a bill to Medicare. So that does occur. They don't have to have it, but it basically there are two options for the hospital to deal with those.
Great, thanks for that. Okay, so I'm going to turn and ask you a couple of questions, Mark. I mentioned it before about the role that we can do and to assist. Our survey that we did of our members showed that 53% of members didn't know where to seek assistance, and only 25% thought they knew where to look for information to assess a situation if they received a compliance issue. So can you just talk us through and confirm for us, you know, the role that we can play? Because a lot of doctors don't know that they can seek assistance from us in this regard.
Yeah, so the simple answer is reach out to Avant to ask for some assistance and guidance. Commonly, the most common letter and the most common one received is this review and act letter from targeted campaigns, where essentially Medicare is asking you to review a number of your billings and associated clinical records just to make sure that you've got them correct. And this is quite often as a result of the data trawling that we've mentioned previously. Avant will be able to help you through this process, and we have both claims managers and lawyers who have extensive and special expertise in this sort of area. Be under no illusion, quite often the periods of time cited in the letter for the abnormal billing run over 1 or 2 years. And what they're going to ask you to do is to review your billing for these specific patients. And that can run into many hundreds. And there will be a very large administrative burden. If your records justify the billing, having regard to the criteria listed in the MBS, well, you should have no troubles. And it's another good reason to document well. Unfortunately, you will still have that administrative burden. So certainly Avant can help by directing you in terms of what needs to be done, what to expect in the following steps. And if necessary, we can help to represent you to explain your particular circumstance to Medicare so that hopefully this doesn't proceed any further. You should certainly take an opportunity to review the Medibank schedule item number descriptors that you use and reflect on your billing and your clinical documentation to ensure that they are appropriate and would support you against any inquiry from Medicare. As we've always said, it all comes down to the documentation.
A very key message, I think, one of the ones that we constantly are on about. Michael, we've had a question about the advocacy that we do at Avant, and I guess flowing from that is the relationships we have with the department. My dog obviously agrees with that question. Can I ask you, can you just tell our members what we're doing in that regard?
Yeah, so I think, Georgie, as I've already outlined, there are these multiple layers of compliance that the department has a work plan to deal with. The feedback that we get from our members is really important because we can actually use that to go back to the department and point out where there have been problems or point out where our members have concerns and help guide future areas so that we basically reduce the stress associated with this. We do advocate for our members too who go through these processes, and we know that it can be very these compliance issues can be very distressing for members. So we're very aware of that, and we do feed that back to the powers that be about the importance of these programs being accountable and transparent, so that people do get involved with compliance issues. We can help them navigate the way through.
Great, thanks very much, Michael. All right, so we've just got a little bit of time just to do a couple more of these Medicare type questions. We've talked about Ask MBS as a source of information. Ruanne, do you just want to just reinforce that position in relation to that? I think we've covered it, but just to confirm.
Yeah, so just confirming that that you read the item descriptor and contact Ask MBS, and the email address of where to find that has been posted in the chat, and that'll come out in the communication after the webinar as well, if that's moving too fast for you. And if you set out information in there that make it clear what you want to answer. If you've still got concerns after receiving that, then come to us and we can help you decipher any of that. Also, when it comes to that, when you're looking at the item descriptor, we had a question come through about documentation and what the requirements are to support your billing. So some item numbers have specific requirements. So if that is the case, it's best to document those in your notes. So that may be something like timed consultations, where the consultation itself needs to take a certain amount of time. Sometimes the easiest way to document that is actually to put it in your consultation note itself, or your billing software may capture that sort of information. But when we talk about that, we're talking about beyond the amount of time that patient's notes may be open on your screen, because we know that that's not always accurate. The other thing in terms of documentation, we had a question about whether or not the letter reporting back to the referring doctor or a letter referring someone on to a specialist can be used as a consultation note. So that's a general question about documentation. So the answer is yes. It can be used as evidence of the consultation, but if you're also using it obviously to satisfy Medicare's documentation requirement, you'll just need to turn your mind to whether or not there are specific things in the item number used for that patient's consultation that you wouldn't normally include in a referral letter, but you might need to capture in your documentation. So then whether or not you then include them in your referral letter, or if that seems bizarre and a bit odd, what you could do is your consultation note could say, letter dictated to specialist X and those details, and then whatever other information, be it time or whatever, captured in your note, but the letter was then the substantive note of what happened in that consultation and the clinical information you needed to reflect from that consultation.
Great, thanks very much, Ruanne. So I think that's kind of gotten us to the end of the section on Medicare. I think the three takeaways for me that I'd like to leave you with on that aspect is, we know that Medicare is complex and can be confusing. You're in good company. In our survey, we found that members you are really concerned about complying with Medicare billing requirements, and you need to know, you want to have more confidence around that. So we have pulled together various resources. We've put some of them in the links in the chat, but we will certainly be sending them out, and there's lots of information available, not only from Avant but elsewhere, and we'll certainly point you in the right direction for that. If you do receive a letter from the Department of Health or from Medicare, then you can certainly contact us for assistance. So absolutely feel free to do that. Okay, so we might change tack and deal with the issue of adverse events management and statutory duty of disclosure. No, it's not. It's the statutory duty of candour and open disclosure. We thought we'd change it up a little bit and work through a bit of a case study. And so I'm going to hand over to Mark to present the case study. Over to you, Mark.
Okay, thanks, Georgie. As you can imagine, this is an enormous topic, and we're really just going to scratch the surface of it. The following case study is purely fictional. I've made this one up, but it's based on, I guess, some personal experience. Mrs. Smith, 76-year-old lady, lives independently with her husband. She's got a history of high blood pressure, some ischemic heart disease, and a bit of anxiety. And she's on all the sort of expected medications for that, including aspirin and clopidogrel. She loses her balance and falls at home, lands heavily on her left side and injures her wrist, which is clearly deformed when the ambulance arrives and takes her off to hospital. And she arrives at about 9 or 10 o'clock at night. She's managed by the resident and the registrar. She's alert and cooperative, clearly in pain with a deformed wrist. So she's given some pain relief. She's sent around for x-ray, which shows a common unit angulated Colles fracture. She's got a big bruise on her left cheek, so they do a CT scan of her facial bones, but fortunately that doesn't show any evidence of a fracture. She's given some sedation, her wrist is manipulated and cast, but the family and friends and the treating doctors don't think she's likely to manage at home, particularly being an elderly lady with one bent wing. And so they admit her to hospital for pain relief and then hopefully for review by an orthopaedic surgeon with a view to definitive treatment of her wrist. A few hours later, while she's on the ward, shortly after midnight, she climbs out the end of the bed a little bit confused, trying to go to the toilet, and she falls. She's helped back to bed, and then over the next hour or two, she becomes increasingly agitated and distressed, and then her condition rapidly deteriorates. She's seen by the emergency response team. She's sent for a CT scan of the brain, which shows a large subdural. She has emergency surgery, but unfortunately the outcome is poor, and 4 days later she dies. The family is quite upset and wants to know how this could have possibly happened. And on clinical review, the CT scan was really of her facial bones only. The ED consultant didn't review the films and was just simply told that the CT looked okay. And it was unclear if she actually had a subdural when she was admitted. And they can't see anything on the limited views of the facial bones. So if we could have a poll question. So are you able to say sorry following an adverse event? Should you apologise but not admit fault? Admit that you're to blame, and it's expected in the circumstances? Say and do nothing? Or your colleague made the mistake, so really only they should apologise? If we could just have people sort of enter their answer into that poll.
Great. And while you're doing that and we're waiting for the results, I thought I'd give you the update on the statutory duty of candour. So this is a particular Victorian issue. So in Victoria, this is going to be a new obligation that's going to commence from the 30th of November. I guess the reason we're telling you about this is because it is new for Victoria. And then what is often the case in this country, something starts in one state and it might end up in another state. So we wanted to update you on that. It's a duty, a new obligation that applies to health services, including public and private hospitals, day surgery facilities and the like. It doesn't apply to GP practices. And it applies when a patient has suffered a serious adverse patient safety event. It builds on the open disclosure framework and it requires a health service to provide a patient with a written account of the facts, an apology for the harm suffered, a description of the health service entity's response to the event, and steps that the health service entity has taken to prevent reoccurrence. Safer Care Victoria has produced some guidelines that need to be followed, and we were involved in providing input into those guidelines. So those of you in Victoria may well have a heads up about this, but if not, then check out the Safer Care Victoria website. So let's, I think we've got the poll results now, and let's see. So are you able to say sorry? Yes, 93% of you said that you should apologise but not admit fault. So most of you got the right answer. Can you talk us through the open disclosure requirements, which are pretty similar?
Yeah, certainly. And once again, I expect that I'll just scratch the surface of this topic. Open disclosure is the open and frank discussion with a patient, family and carers regarding adverse events that result in harm to a patient while receiving healthcare. While it's often thought of as a formal process within hospitals, it's really more of an ethical, moral and professional approach to dealing with adverse events. It is recognised and endorsed in many jurisdictions, including Australia, UK, Canada, New Zealand, parts of the United States. Broadly, the elements are, firstly, an acknowledgement that an adverse event has occurred and an apology or expression of regret using the word sorry. So we are sorry or I am sorry. A factual explanation of what has happened and an opportunity for the patient and or family to relate their experience and their understanding. Then there's a discussion of the potential consequences of the adverse event and an explanation of the steps taken to manage the adverse event and prevent recurrence. Importantly, adverse event does not mean blame, fault, or negligence. It's common for doctors to fall on their sword when something doesn't go well. And frequently an objective review concludes that the clinical management was appropriate. And so this is the importance of expressing regret for what has happened, but not saying it was my fault. From a medico-legal perspective, even an overt error doesn't necessarily mean grounds for litigation. The acknowledgement of the adverse event and expression of regret is a critical step in maintaining trust and transparency and avoiding legal action, which is truly in everybody's best interests. As they say, the only thing worse than an error is a cover-up. Open disclosure reduces the perception of a cover-up, and it's important, as abandonment or failing to address adverse events is a common theme and one of the reasons that patients actually sue doctors. So let's imagine this case study. Imagine if this was your mother, your wife, your sister, your daughter. How would you like the doctors involved to respond? Each case swings on the particular circumstances, so it's very difficult to be prescriptive. But in this case, you'd consider expressing to the family, there may have been a missed opportunity to identify the bleeding around the brain at an earlier stage. I'm terribly sorry for what your family has had to go through. Go through a very quick clinical summary and ask them, what do you understand about what has happened? Politely and gently correct any misunderstandings or misconceptions about the clinical circumstances. And then you may say, it's unclear exactly when the bleeding occurred. The doctors have been counselled. The matter is subject to an ongoing review. The department is developing further guidelines regarding imaging, and further and ongoing education is being developed. Would you like us to provide an update on these matters as they go forward? Now, there is abundant literature supporting open disclosure to reduce litigation. The conclusions as a direct link are not as robust as we'd like, but that's because the clinical and legal landscape is jurisdiction dependent and it's rapidly changing, and the circumstances of each individual case are diverse. Indirectly, literature regarding the reason why people sue doctors is very convincing. Concerns about standard of care, lack of information about what has happened, abandonment, not being heard, accountability, and finally compensation. Intuitively, open disclosure appears the best approach to manage these. There are abundant resources available publicly regarding open disclosure, many training programs, and extensive literature. And these principles can be applied in all settings. Thanks, Georgie.
Thanks very much, Mark. That was a great summary. I have a couple of questions for Avant in a sec as the other lawyer on the panel, but I did notice a question in the chat about who's responsible for open disclosure under the statutory duty of candour. I think the best thing to do is to have a look at the guidelines, because there is a process to follow in those Safer Care Victoria guidelines, and that will outline who needs to be involved and the process for doing that. Just to be clear, Safer Care Victoria, the statutory duty of candour is a statutory obligation that exists in Victoria. It's very similar to the open disclosure framework that applies as a matter of accreditation, as a standard for accreditation in other health services around the country, and is also an obligation really under the medical board's code of conduct if there is an adverse event. So I'm not sure I've clarified that, but that's essentially the situation. Ruan, can I ask you a question? What's the law around apologising? Is it an admission? Can it be used against you in litigation?
So the easy answer to that question, Georgie, is no, it can't be used against you. And as Mark alluded to, we live in a federal system. Each state and territory has their own laws, but each of those jurisdictions in Australia do have specific legislation that essentially protects any apology or statement of regret being made after an incident that has occurred from being used against you in a court if the patient, for example, decides to bring a civil claim or sue for damages. The whole idea of this legislation, much like the open disclosure framework and laws changing that we've seen in Victoria with the statutory duty of candour, the whole idea is actually to encourage clinicians to feel comfortable expressing that regret and having that conversation with patients, so you can feel comfortable to say sorry. And as our poll question teased out, that's quite different from feeling that you have to accept blame for the situation or provide all the answers after a situation. It's really about starting and keeping those lines of communication open.
Thanks, Ruan. We've also received a question from a member about whether they need to contact us at Avant if they are going to be involved in an open disclosure process.
I guess it depends on your comfort of going through the process and the comfort of or the clinical situation itself. Certainly, if you have concerns, if you receive correspondence or a phone call, we'd normally suggest providing a brief covering letter saying thank you for expressing your concerns. I'm considering this, and I will get back in touch with you for a week. Feel free to contact Avant for further support and advice in the circumstances. So we're more than happy to provide some advice. Quite often we can provide some assistance in drafting responses if necessary, or how to approach it, as well as assessing the medico-legal risk to you in the circumstances themselves. So we're always happy for you to contact us if you're concerned. Thanks,
Mark. And Ruanne, what's the insurance position?
Yeah, so sometimes under your insurance requirements to notify incidents, it would be a good idea to let us know so that you can rely on that and trigger that notification requirement. That doesn't necessarily have to happen before the open disclosure conversation, but as Mark said, we can absolutely support you in how to have that conversation. But if you do need to notify about the incident, then let us know, and that might also apply if it's a public hospital incident. You might want to let your public hospital know through their processes.
Great, thanks very much, Ruanne. So just to, Mark, did you want to add something? Sorry.
There was just one question I noticed about asking who is responsible for the open disclosure process. Under the statutory duty of candour, I've got to admit I don't know the answer to that. I don't work in the Victorian jurisdiction. In most public hospitals, they will have a process or a person or even a team who undertakes these discussions. It should include the doctors that are involved, but usually it's undertaken by the senior doctor who's taking that process.
Great. Thanks very much, Mark. That's terrific. Okay, so just the takeaways, I guess, in relation to open disclosure. We'll move to our final topic shortly. Basically, open disclosure is good practice. It's a requirement under the Code of Conduct and accreditation requirements for patient safety events and near misses in public hospitals and private hospitals and the like, the hospital accreditation standards. We have lots of material available on open disclosure. The Safety and Quality Commission has material on that. And in Victoria, it's going to be a specific legal statutory obligation. That obligation actually in Victoria applies to at the board level of hospitals, but it will filter down. So the boards of hospitals are ultimately going to be responsible for implementing the statutory duty of candour. But obviously what that means is that the doctors are going to be involved in the conversation. So expect more information about that if you haven't had it already. Okay, so we're going to move on to our last topic in the last few minutes that we have. I'll just do a bit of a segue, which is that we know that adverse events, among other things, can have a significant impact on staff members, and staff debriefs and support are really important for dealing with adverse events. So obviously, if you're involved in a patient safety event, it is really important to look after yourself. And I think there's increasing recognition of the traumatisation that can occur to practitioners involved in these events. So that really segues into dealing with psychosocial hazards in the workplace. And I'm going to hand over to Ruanne because this is quite a legal topic. Ruanne, over to you.
Thanks, Georgie. So we're going to start with a poll question for you all, just to tease out whether or not your practice or hospital or other workplace has a psychosocial hazard policy or framework in place. Some of you may know, some of you may not, and we're going to talk about what that involves and what that means. While we're waiting for those results to come up, Michael, what have you seen in your practice about some of those pressures and stresses that Georgie just mentioned?
Yeah, Ruanne, I don't think it's an understatement to say it's been a very stressful time. Patients have often been unhappy, very stressed, sometimes aggressive, and I think we could say similar things about our colleagues. Like we've had lots of people off sick, we've had changing work environments, and we've all just tried to adapt as well as we could, but it's been very challenging.
Yeah, and I know talking to our members and helping them on the medico-legal advisory service, we've certainly seen that, not just over the last few years, but generally with what has to deal with as a healthcare professional. So we might have the poll results up. So we can see that about 12% of you do work in a workplace that has a psychosocial hazards policy. About 25% don't. Most of you, or 45%, are unsure. And some of you would like to know what a psychosocial hazard is. And so lucky for you, we're about to talk about that. So really, when we're talking about psychosocial hazards, we're talking about anything that could cause psychological harm. So separate from physical harm, impact on someone's mental health, their emotional health, their cognitive health. And that might be a hazard that is arising from your work environment itself, the physical environment of it, what you're being expected to do in it, the way that it's set up, the structure of it. It might actually also be the design or the management of your work itself. So that might be role clarity or lack thereof it. It might be the demands of your job. And that can include things like the fact that as a health professional, inherently you are dealing with traumatic and stressful experiences, as Georgie mentioned. It might also be interactions or behaviours that actually take place in the workplace. So this is where some of the concepts that you might be more familiar with, such as bullying, harassment, violence or aggression, come into play when we're talking about psychosocial hazards. Essentially, what's changed is that these sorts of things used to effectively be managed as human resource issues or HR issues. But what we've seen now is those have been incorporated into the obligations of work health and safety that are incumbent upon employers to fulfill. So there's actually a recognition that these need to be managed within that framework. And they need to be proactively managed. So that's not about responding to an event once it's happened. It's about actually assessing your workplace and the work environment, or the employer doing so, and conducting a risk assessment. What are the psychosocial risks or hazards? What can we do to mitigate these, or what can we do to actually eliminate these? And actually going through that process in response to the risk assessment. This has been articulated in the Safe Work Australia framework, and you can see the code of practice has just been posted in the chat there. We talk about our federated system of different states and territories. So in line with that, each state and territory then actually is responsible for regulating work health and safety. So each of the jurisdictions need to then implement those within their own location. We've seen that has happened in New South Wales. And there's also been some steps in Victoria to have that occur as well. Those regulations in Victoria are in draft form still, but in New South Wales, the regulations were actually implemented on the 1st of this month. And effectively what they do is set out the responsibility on duty holders, let's call them employers, or otherwise they're called PCBUs, and how they actually have to deal with and assess the risk to psychological health at work, what they need to do when they're developing their control measures, and what they need to look at. So this is all about that proactivity that we were just talking about. The New South Wales framework also has the code of practice, which is useful for some practical tips about how this works. The other thing I just wanted to mention in New South Wales, which I think is quite an interesting development, is some changes to the Crimes Act, which came in this month as well. It's been a busy month, which actually introduced new offences for assault, intimidation or harassment against frontline healthcare workers, as well as some other frontline workers. So I just think that's a real recognition of some of the stresses that we were just talking about that have impacted upon healthcare, emergency workers and others in recent times. And some of those new offences come with some pretty hefty penalties. They apply mainly in the public system, community health centres and public hospitals. So it's just something to be aware of if you do work in those workplaces, to actually understand. And I think it's really going to hopefully change the landscape and change the expectations in this area. I think it's really interesting to look at that in the context of the medical board's symposium about the culture of medicine that occurred earlier this year, and their media statement, which is available on their website, sort of looked at recognising that poor workplace culture actually impacts on patient care as well. So the main things in relation to these changes to be aware of is that that shift towards a proactive approach, and the requirement to identify those risks in advance and then to put measures in place to actually manage those.
So, Ruan, just to clarify, that applies to all workplaces, whether it's a hospital workplace or a private practice?
Yeah, so those are in relation to all workplaces. And it's also looking at the role of the individual as an employee or anyone to actually sort of call out and recognise those risks as well. So we're really seeing that framework shift to actually calling out risks, identifying risks before they create a situation.
And it's a bit like, I think someone explained it to me as, you know, we've got a lot of work health and safety issues around physical risks. So, you know, moving the chair out of the way so that or the box out of the way so you don't fall over it. So this is basically an extension of all of those WHS requirements to psychosocial hazards, i.e. things that can cause you psychological harm. Is that right?
Yeah, absolutely. It is really, it's moving from how to lift the box to actually how to structure your workplace. And actually to recognise that, I think we've had one question come through. So, you know, about aggressive patients and actually that creating that's a risk. And the steps that you can take to mitigate those. Now, obviously, you can't always control the behaviour of others, but what you can do is put frameworks in place that support your employees that are dealing with those situations. And what's going to be appropriate is going to depend on your workplace, and that's where the codes of practice come into play.
We've just about run out of time, but I do want to ask Mark a question that's come through. So someone's asked a question about the support that a hospital can provide you as a doctor who's been who's experienced some either an adverse event or a traumatic event or perhaps one of these psychosocial hazards. Can you answer that question for us, Mark?
It depends very much on the hospital. Obviously, the larger the hospital, the more resources and the more teams they will have in place. Most hospitals will have some form of governance and quality and safety unit that may be able to assist, and the Director of Medical Services is usually the go-to person for advice and support in that regard. In the private setting, adverse events need to be dealt with by the treating practitioner. And as I mentioned before, quite often in larger public hospitals, it's dealt with by a senior clinician, but with the involvement of the doctors who were responsible for the patient's care.
Thank you. Okay, so I think we're out of time. So it gives us a minute to do a quick wrap. Have we got some key messages? I'm going to start with, actually, Mark, since you've just been on the mic, over to you. What's your key message for our members?
Adverse events occur frequently. You're usually not to blame. There is no problem with expressing regret for the outcome, and dealing with it using an open disclosure type framework is beneficial for all parties concerned.
Great. Thank you. Ruan, over to you.
Yes. So look, I think it's really encouraging to see some of these legal changes recognising the psychosocial or the mental health impact of workplaces, not just the physical health. Watch this space as we expect more jurisdictions to bring them into play, and obviously seek support when you do face those issues.
And then looping back to our wonderful CMO for the final word, Michael, over to you.
Thanks, Georgie. Look, I think it's a simple one. Medicare is complex. It's really important to understand the rules around the item numbers that you use, and that you understand what's being billed under your provider number.
Awesome. Thanks very much, Michael. So that brings us to the end. Can you please do the survey when you leave? We're really interested to have your feedback on how you think this worked. It's the first time we've done one like this. So please give us your feedback. We've got lots of topics. We were hoping to do and more, but we've run out of time for and more. We've got lots of topics for next time round, but we'd love your feedback on what you would like to hear more of from us. We hope to do these regularly if you think that they're useful. So thank you, everybody, for joining us. I hope that you have a really good evening, and we will send the links with a link to the recording of this video out to you after this, well, in a few days or a week when we have it all ready, but we'll certainly send it out. So thanks very much for joining us, and have a good evening.
Thank you. Good night.